regard to the Watkins matter, there really was no way to circumvent the truth. He had served 8 months in prison. But even in the Watkins matter, what I would point to this Court's attention is that Mr. Dadisman was not entirely forthright even in that. And that matter, per the respondent, to them is the most important instance in this case. And I would call this Court's attention to the transcript at page 133. The question upon cross-examination of Mr. Dadisman was, so it is your testimony here today that it was signed, and that makes reference to the check in the case. As this Court recalls, there was an $80,000 check that had been received from the insurance company and was deposited into the bank. Mr. Dadisman's answer was, I don't recall, Ian. All I know, I don't see how the bank would deposit it in there without both signatures. Moments later, Exhibit D was introduced and presented to Mr. Dadisman. That was a photocopy of both sides of the check. And once he looked at the check, Mr. Dadisman acknowledged on page 135 at line 10, the signature's not here. I think that that's especially important when we look at the facts surrounding this. Mr. Dadisman had gone through criminal litigation for years, had gone through a plea, had gone to prison. He had served time in prison. He'd been on post-release control for some time, had been involved in the disciplinary proceedings for some time, and yet still at hearing is still not acknowledging and accepting responsibility for what he had done. He is still arguing the facts of the case. There are several matters, as I had stated a moment ago, here, but I would also point, just as a kind of a representation as to what I think gives insight into how or indicates Mr. Dadisman's behavior in this case. And I would point to the Baylog matter. I think that this kind of encompasses his lack of acknowledgement throughout this entire proceeding. And at page 417, Mr. Dadisman continues to attack Ms. Baylog by stating, in 15 years, this is the most difficult client I've ever seen. He went further a moment later to say, I think she's misconstrued several things. So the point here is he's not been contrite. He's not accepted responsibility. He has continued to deny absolute wrongdoing in this case. The final statement that was made in respondent's brief was that at all times, Dadisman acknowledged and has been contrite about his wrongful conduct. He has never minimized the seriousness of his acts for which he served time in prison. Again, I've addressed that, the issue of the instance warranting prison time. But again, with regard to the other cases, the panel members, not only did I as counsel give Mr. Dadisman the opportunity to provide some justification, the panel members did that as well. And one of the panel members at page 550 of the transcript asked Mr. Dadisman, do you know how frustrating this is? And that comment was with regard to the neglect of the client matters. And Mr. Dadisman's response at line 12 was, well, I do, but then some people, are especially needy, okay? And that was his response to that. And that's not the type of response that would give, or that should give this Court comfort in giving a sanction anything less than permanent disbarment. There have been several cases that the relator has relied upon in its answer and would ask the Court to consider in this case. Additionally, there have been a line of cases that have been issued since the filing of the brief. In those cases, I would submit are either equal or even less than that of Mr. Dadisman's case. In this case, pursuant to Section 10, when looking at the aggravated circumstances, I submit that 7 are present. Mr. Dadisman acted selfishly. He acted dishonestly. There was a pattern, as was recognized a moment ago, of misconduct. There were multiple offenses, a lack of cooperation during the disciplinary process, submission of false evidence, false statements, and other deceptive practices during the disciplinary procedure. The victims certainly were harmed and still have not been made whole today. There's been an absolute failure to make restitution. And I believe that the only factor of mitigation, the absence of prior disciplinary record, should not outweigh all the other facts and circumstances found in this case, should not allow for Mr. Dadisman to have a sanction anything less than permanent disbarment. As the panel noted at the time of the hearing, and as was subsequently adopted by the board, the respondent was, quote, most of the time evasive, dishonest, and patently untrue. I believe here in close that the question that begs response is, why should the respondent be afforded a second chance? Why should he be able to practice law in the state of Ohio? It's been pointed out here a moment ago, and I would just reiterate, I think that the strongest answer comes directly from the mouth of Mr. Dadisman in two excerpts from that proceeding. Again, there was ample opportunity to give some reason, and even as counsel for relator, I wanted a reason. But the respondent did not provide any reason, justification, or excuse, or even apology that day. The first excerpt was found at page 537. So why do you want to keep it? And that's in relation to the license. Answer, you know what? Question, why should you? And the answer was, you know what? I don't know why. There's a lot of questions that I have not unraveled myself. There's a lot you asked me. Why? I wish I could give you the answer. Finding that somewhat unsettling, another opportunity was given to provide some justification as to why the license should be kept. And that exchange was at page 538. And that question was as follows. In direct response to the question, why should you keep your law license, you yourself don't even have a good reason for that. And the answer was very clearly, no, I don't. I really don't. So in close, I would simply state that Mr. Dadisman's conduct cannot be tolerated. In order to protect the clients and the public, to ensure the administration of justice, and to maintain the integrity of the legal profession, the relator moves this honorable court to issue an order that respondent be permanently disbarred from the practice of law in the state of Ohio.
Thank you, Mr. Friedman. Mr. Potat.